Hi everyone, and today I am with you, your host Kriti Shastri. You're listening to me on the Conscious Score podcast. Today we are going to discuss about something really nice, and that is the litigation legacy. Do you need to have a legacy if you want to stand alone in the field of litigation, or if without being that also can you do it? We'll also talk about top 3 myths that people have while practicing, or thinking about litigation in India. So that is all we want to discuss today. And more so important is, if you find it interesting, if you find it was helpful for you to decide your career, then please press the bell icon as well as subscribe to our channel, and we'll have more such discussions on it. And let's welcome our guest, Mr. Ajay Awasthi, today. And he's working as an advocate in the chambers of Mr. Mahesh Jetmalani, son of Mr. Ram Jetmalani. He was also working with Ram sir for a really long duration. And right now, if I say, what does he do? He practices all over the place in India: Supreme Court, High Court, Delhi High Court, Bombay High Court, whichever court you say. The matters that he specializes in are constitutional law, service matters, electricity matters, and NPOs, and constitutional law and arbitration matters. However, his heart and his hardcore heart lies in criminal law as well. So that is all about him. He's also an empaneled lawyer in the with Madhya Pradesh Vitran Electricity Limited, and to represent the Supreme Court of India. So a very warm welcome to you, Ajay.
Thanks a lot. Thanks a lot, Kriti, for having me here.
Yeah, and the best part was you the idea behind this entire podcast was to make the people realize, to make those people, those students realize, who are aspiring for law as a career, or maybe those who are still planning as to which having which kind of career option that they have, whether it's litigation or it's going into the corporate, or working with a bank, or maybe working as a research analyst, or doing anything else. In today's time, we have so many field in law. So let's give them a bird's eye view from your eye as to how litigation in India is all about.
It would be a pleasure to explain with whatever limited knowledge which I have in this profession.
Right. So tell me the first thing, why do they say that, you need to have something like a parent, a grandparent, or maybe someone's office in litigation to enter into litigation? Is it that litigation is a legacy that you need to have, or you can be a first generation lawyer and enter the world of litigation?
To be very honest, Kriti, I will be the last person to agree with this myth in which it is said that you need to have a legacy in case if you want to excel in this profession. The reason is that, if I start with my own career, I have no one in this, all my family members, they are into business, and
Right.
they know nothing about litigation or legal profession as such. But I thought of joining litigation. I mean, legal profession. I studied my law. Until then, I was not even aware of what law is all about, apart from what I've seen in different movies. So, then I opted for law. I pursued this law as my career. And, gradually after doing my internships and everything, the first office in which I was appointed as a junior associate was the good office of Mr. Sri Praveen H. Parekh. So
Right.
it was more like it is one of the best offices of the country in which you get whole lot of experience of working on different categories of matters. So I did not find any such difficulty just because I was a first generation lawyer to enter into such a big office. And gradually I worked with Sri Ardhendu Mauli Kumar Prasad, and then I worked with Sri Ram Jetmalani, and then I'm working with Sri Mahesh Jetmalani. And I think that my work has been acknowledged at all the offices, and which is why I was able to excel in this profession. It has nothing to do with whether I belong to a family and one of my parents is in litigation or even in this profession. So I don't agree with this myth. The reason is that what actually matters is your own hard work. In case if you are able to develop those set of skills which are required to be a good lawyer, then you can excel in this profession. Of course, initially for a year or two, you might have some kind of convenience because you have a better exposure in case if you have anyone in your family as a lawyer for the guidance sake. But
Right.
in case if you're not interested in developing your own skills and you limit yourself just because you have someone there, some of your family member or your parents as a lawyer, so you will have a knack over the others. That's not the case.
Right.
I think that in case if you don't have skills which are required to be in litigation, then you will not be able to survive in this profession, no matter who you are, no matter what you are.
Right. And also tell them about, how did you figured it out that, this litigation is for me. I am meant for litigation and this is my core.
See, initially, I was not interested. See, I'll start when I actually opted for my law college. So it was like, when I thought of studying something, one thing which was clear there in my mind was that I have to do something in law. That
Mhm.
thing was clear. I did not want to enter into my family business, so that was clear that I have to do something in law. When I entered into a law college, then the first what now good thing which happens nowadays is that when you're even as a law student, you have an opportunity to intern under various lawyers or maybe in an NGO or maybe in a corporate firm and law firms in an under an in-house counsel. All those opportunities you have when you're working as a, when you're pursuing your law in those 5 year or 3 years integrated course, whatever it is. So then I actually did my internship in a very, organized manner. I did internships. My initial internship was in a state human rights commission, which generally people do after their first or second semester. I've done that internship. Then I thought that okay, now this has been done. This is not something I cannot join per se state human rights commission and sit in an office and do some kind of research or prepare statistics. That's not what I'm made to do, or maybe I'm not good enough to do it.
Mhm.
Then I did my internship under a lawyer. Then I did my internship in a corporate firm. Then I did my internship in a company. Then I did my internship in a research institute. Gradually, I did my internship in an international organization, and then I thought that okay, whatever internships I've done, uh, the thing which I enjoyed the most, or the work which I enjoyed the most, was had everything to do with this litigation. So
Right.
then finally, I concluded for myself that okay, you're made to, or maybe you enjoy doing litigation, and you should proceed accordingly. So that's how I actually planned my career, and I thought that okay, litigation is one thing which I can do all my life, and I proceeded.
Right. And I think these students should also understand when they are in their college that it is, from the first year itself, you have a mindset, okay, I'm supposed to do this. There's nothing like it. You need to explore all your options. You need to go and find out what works best for you, what you like doing, and where you can excel. So just take out those points, these 3 points which I've mentioned, and accordingly act in your career. It cannot be from the first year itself with a premeditated mindset, oh, I'm going to do this. You can't, because you will have to explore options. Unless you explore, things won't work out.
I personally feel, Kriti, that when you're leaving out an option, you should first experience that option before leaving it out.
Right.
So it's like I did not want to you know do those corporate join a corporate law firm and work as a corporate lawyer. So first I took a first hand experience by doing an internship in a good law office, and then I thought that okay, this is not something which I want to do. So I think that before you rule out anything, it's better that you take your experience from whether you actually enjoyed that thing or not, and then decide something. Because as a first year law student or second year law student, without even uh, joining a law firm, if you say that okay, I don't want to do that due diligence, when you actually don't know what due diligence is all about. So
Right.
then this is something which is you're not justifying your career as such, and there has to be a career architecture, and one should plan accordingly. Even it should be like everything should be done in an organized manner.
Right. And I think then things fall in place because you kind of realize, okay, fine, now I've done so many things and this is what I felt was for me and I can excel in it, so I'll do it. So that
Yes,
that
that's
that
right.
is how it works. So my
That's right.
next thing which was there in my mind was, some people say that litigation isn't rewarding. There's a myth that litigation isn't rewarding, especially initially, because later on in life it is rewarding, as we have seen with various lawyers. But what about the initial years when they speak about litigation isn't rewarding?
See, maybe again I'll share my experience. It has
Yes.
been rewarding to me since day one. So
Okay.
it's like when I worked at the good offices of Sri Praveen H. Parekh, there my senior took a good care of me, and it's not only about now here when you join a litigation chamber, there is a difference between joining a corporate law firm and joining a litigation chamber. In case if you're joining a litigation chamber, it's more like that guru shishya relationship which you share with your senior,
Right.
because you directly deal with your senior guides you on things which are required, and he works more like a mentor to you, like a teacher to you, and he explains you everything.
Right.
So I was fortunate enough to work with Mr. Praveen S. Parekh, then Ardendu Moli Kumar Prasad, and then Ram sir, and then finally I'm working with Mr. Mahesh Jetmalani. So that way, I have been taught to very well by them, and regarding the rewards, they've taken good care of me. So
Right.
it's like, I can say that maybe even tier one law firms would not have given so much of remuneration to their juniors, which I've got in all those offices.
Wow.
So it's like, at the end, what matters is your own hard work. If you're
Right.
ready to work on your own set of skills, and if you're ready to work, learn as soon as possible those all important things which are required to be learned, then you can develop your own independent practices. The most important thing in working in a law chamber is that in most of the offices, you get independence to do your own matters.
Right.
So when you do your own matters, you can charge your own fees. When you can charge your own fee, that is another remuneration which you are able to generate for yourself apart from the salary which you get from your senior's office.
Right.
So and then when it's like you make your own identity when you argue a matter there in court. So that is
Yes.
another reward which you get apart from those financial rewards when you conduct a matter.
Right. I think that is a satisfaction which is more important. I mean, you can be having a lot of money in your bank account, but if you're not satisfied, it doesn't really, you
That's
can't really work
that's
with it for long.
that's one aspect. That's actually there. That if I argue a matter and I get an appreciation from judge, I think that maybe I will be waiving a fee of this matter. The appreciation which I get from a judge is far more important to me than getting a fee from the client in some matters. So
Right.
that's a different thing. That's satisfying, but that's uh, individual satisfaction which one gets. Maybe people might not have the same satisfaction which I have in appreciation from a judge. So
Right.
in that case also, otherwise also I feel that when it comes to finances, you can earn from your first year itself. You can get good money for yourself. You can earn uh, bread butter for yourself, and maybe you can earn more than people working there in tier one law firms.
Right.
I feel that in litigation, it's not like that you will not be able to earn anything and it's all struggle for you since first year until and unless you settle yourself as a lawyer. There are many people with whom I've seen there in litigation, and they have been, they don't want to leave their chambers. They just want to work under the senior and, earn money under the senior in place of doing their own independent practice,
Right.
which means that they are satisfied working under
And
a senior.
and
So,
learning as well. So it
and
is
learning as
working
well
and
as they
learning.
might be getting that money also. It's
Right.
not only about learning. Of course, when you work under a good senior, you learn all your life. It's a profession, which is why it is called a practice, because every time you practice.
So this is what we were discussing about. However, I would like to ask you, what are the factors that a youngster who's just entering into this field should consider or should, build in himself to become a good litigating lawyer?
See, there were many factors, but the important factors which I think are, I mean, the factors which are very important. One is that whatever you do, you should be consistent with it. It
Right.
should not be, at times you might not get a good order, so you should not be demotivated just because you have not a good order. Okay, maybe I'm not made for litigation. At times, what happens, that you get multiple complicated cases which in which it's difficult to get because good orders, and you argue a couple of cases and you feel like, okay, I'm not able to get relief for my client, maybe I'm not made to do litigation.
Right.
That's not the case. So that way I feel that the first thing which is important, be consistent. Maybe you get a good order, you may not get a good order, that's a different thing altogether. But what you have to do is whether you have given your 100% to the best of your abilities or not,
Hmm.
and you should be ready to develop those abilities and polish those skills which you have in yourself to be like oratory. Take for an example, you
Hmm.
should be mastered in presenting your case. You should have good argumentative skill. You should have a critical mind. You should have an analytical mind. You should be you know you should not watch the clock while working on a matter. It should more be like, until I'm done with this matter, I'm not getting up from my chair.
Right.
So you should be hardworking.
Right.
So at the end, that's what matters in case if you want to excel in this profession. Rest everything, gradually when you go ahead with your practice, you learn how to deal with clients. At
Huh.
times because this is another important aspect which one should, I think that is something which you can learn on your own. When you deal with a client, you get to know that, okay, this is one client, because every time every person is different.
Right.
Every individual is different. At times, if you show too much of positivity to the client that, okay, that's a very good matter and I'll get so much good orders for you and all those things, but obviously the client might say, oh, okay, I've heard it and multiple times from different lawyer. I don't think that I don't have that confidence. So you have to be truthful to your client. You should just not be, faking things to him just for the sake of a matter. It should be
Right.
like, explaining him the nuances of his matters and explain him that these are all the possibilities. Like there are multiple times in which I've told my client that this is one matter in which it's very difficult to get relief because all the important evidence. I'll share one experience of an arbitration proceedings which I
Sure.
was,
Sure.
yeah. So it was like, there was a matter in Delhi, DISC, Delhi International Arbitration
Hmm.
Center. So a client approached me, and when he approached me, it was more like all the evidences and other things were recorded, and crucial evidence on part of the this person, this respondent. I was appearing for the respondent in the matter. So crucial evidences which were ought to be recorded were not recorded by the other earlier lawyer.
Okay.
So when he came to me, so it was more like now it's at the final stage, at the stage when I have to argue the matter. It's sort of listed for final hearing, and you have come up to me, and I feel like that now it's very difficult because all those crucial evidences
Are
which were to
not
be
there.
recorded before
Huh.
are not there. So it's very difficult to argue this matter. I might
Right.
not be able to get you good relief.
Right.
And then that client, he said that, okay, whatever it is, I just want you to argue the matter.
Oh, wow.
And then I thought that, okay, I'm telling him that I might not be able to. I told him that, why don't you get your earlier lawyer conducted this complete arbitration proceedings for you. Let him argue the matter. Well, no, sir, I
Right.
want you to argue the matter. I said, okay, then I'll proceed with it. I finally, on that last date, I argued that matter, and fortunately, I got him a very good order. So maybe,
Okay.
but then I did not give him that fake assurance that I'll get a good order for you, because I
Uh-huh.
was aware that in case if I'll get a good order, that may be based on some precedents or something, some
Uh,
Supreme Court judgments on these arbitration proceedings where I'll be able to admit some another evidences. So that was done, and fortunately we won that matter.
right.
So that's how it is. But I never fake things to the client, and I think no one should. In the long
Yes.
run, it affects you. Initially,
Right.
you feel like, okay, just to get that matter, I'll get you a good relief and all those things. That should not be done.
Right.
Whatever the
And
position of the law. Mm-hmm.
then probably like they won't be that much, having confidence in you. And then even on, it's all about word of mouth, I believe, in even in this field. Like, if someone is
Yes,
like,
yes. I
yeah, you're just telling them on the basis of superficially that, everything's fine, everything's all
mm-hmm.
right, and then suddenly one day they get a shock. So that is
True,
also
very true, very true. That's absolutely. The client should be mentally prepared for whatever is coming up to him. So
right.
that should be there. And one more important thing is that at times when you don't know that particular law, in the initial years of my practice, when I was not pro with all those laws, which maybe I have good enough knowledge to give those. I mean, if I can just at the first meeting I can discuss it with the client and I can provide him a good. Aspects of his matter. But initially, in first few years of my practice, I was not aware of those laws as much as I am now. So,
Right.
and gradually, maybe something more I'll be able to learn. So, initially when I used to take up a matter and I was not able to give him the proper advice on the matter, I used to tell him that let me read your matter, let me read that law because I don't know that particular aspect of law. I'll have to read and then I'll explain it to you.
Right.
And I personally felt that has worked more into my benefit because at that point of time when I used to take time from my client saying that I'll have to read your matter, I'll have to read that respective law, and then I will be able to advise. So that then the client, they used to feel that okay, this is one lawyer who is not just beating around the bush and he actually wants to read and then explain it to me.
Right.
So
He feels
so
like, you are serious about it, and he feels connected also because you're assuring him the right thing.
that's how. So I
Right.
think that truthfulness is one thing which is very important in this profession. Initially,
Right.
you might feel okay, this is something which is not getting me good, maybe good clients or maybe good reputation. But later on, and let me tell you that in a couple of years or maybe some more years of the practice, you'll realize that truthfulness is the most important criteria to be a good litigating lawyer.
Right. Because they say it also, like if you're working with someone, how do you find out whether, the person is honest to you? Because everyone is going to give you something or the other. Every lawyer
True.
has something to offer
Hmm.
to you. But then I think that is a distinct, altogether belief that they have in their lawyer is very important.
Very, very true. And then,
Right.
my major practice is of Supreme Court. So in that case, what happens is that by the time the matter reaches here, the client is aware of most of the things. So if
Yeah.
you beat around the bush, they realize that, okay, this is something, I know what my matter is all about and what he's saying is something which is, you know, uh,
Not making sense, huh?
out of the country. It's not making sense. That's how
Sense,
it is.
right. So, right, that was great. Oh, can you tell us a day, a normal day in your life as a litigating lawyer, how it starts and how it ends? I mean, tell us
Because
everything which is related to law, going to court, maybe briefing your senior, maybe everything, whatever can come into
every day is a different day in litigation.
it.
That's what I feel because every time, maybe initially for first 10, 15 years, it's more like you should be ready for something new in in a day. So
Right.
it's more like, in my earlier office where I used to work, I had to reach office at 8:30 in the morning. So it
Uh-huh.
was like my day used to begin at 5:30 because I had to make my own notes before I brief my senior, and then 8:30 I had to reach office. By 9 we used to reach at Supreme Court chambers, and then by 10 o'clock we used to be there in court. That's
Mm-hmm.
how it was. When when it was when I used to work with Mr. Ram Malani, in that case it was more like all his preparation he used to do before 8 p.m. So it was like before 8 p.m. he used to read all his briefs and everything which was relevant uh, for the subsequent day. And then it was more like that, okay, I can afford to reach office at 9:30 also.
Right.
But then, so everywhere, whenever you work somewhere, as a junior, as an associate working in some law chamber with a senior. So every time you have a different exposure because every office has its own work culture, and you have to mold yourself accordingly.
Right.
Regarding my own personal matters, it's more like now you have independence to have your own approach in that matter, and you learn a lot. In case if you conduct your one matter and conducting three matters with a senior, in one matter you conduct on your own gives you a whole lot of knowledge. After
Mm.
a point of time. Initially, of course, it's important to work with a senior because you don't have that grip over law. You don't know how to approach before in a brief and how to present your case before the court. But gradually, day by day, you get to know that okay, in your own matters, you're learning a lot. So when I conduct my own matters, in that case, I wake up quite early. I prefer waking up at 4 o'clock in case if I have a matter. In pandemic, I can afford to wake up late. That's a different thing. But otherwise,
That we
I
all
wake up.
have.
Yeah. So because I virtually everything is working virtually, so I can sit here at my home and argue a matter from a comfortable place. But otherwise, I used to wake up when I have my own matter. I wake up quite early. I study that matter. I think about it. Then I think about my arguments in my mind how I have to present. And then at times whatever you think uh, is something different. When you approach the court, you feel like okay, there is altogether a different question which a judge wants to know the answer of.
Right.
So then you feel like okay, what I thought was something which is immaterial. I have to first satisfy the bench and then I have to proceed accordingly. So this
Right.
is something which happens. So every day it's a new thing, it's a new learning experience, a new matter, and gradually you cannot afford to say no to the matters. In case even if I'm interested in criminal law, but if I get a good matter in relation to a service law,
Mm-hmm.
so I can't. I generally not a person who says that. Oh, I can explain it to the client that this is initially like in third or fourth year of my practice when I was not into service laws and all. So I used to candidly say to my client that okay, service law is something which I'm not uh, much aware about. So in case if you want me to pursue the matter, then I'll have to read that law. And
Mm-hmm.
when the client used to show his confidence, I used to read that matter, and then so every day there is a new law. You can't say no to a brief.
Right.
When it comes to litigation, I mean the traditional litigation, what happens is that uh, 5 years, 10 years, or 15 years down the line, the clients they realize that okay, whatever criminal matters he has argued or whatever good matters he has got, he was able to provide us good reliefs in those matters. you know so gradually that labeling of being a criminal lawyer or a civil lawyer or a constitutional lawyer, that happens after you conduct proceed with your practice for a couple of years, and you feel like okay, in this matter, because I've conducted more matters in criminal law, so I've become a criminal lawyer now. That's how it is.
Right. So can you tell us, how we would like to know how to brief a senior, basically, how do you brief your senior and how do you read it and how do you, because this kind of a skill no one teaches you.
Yes, that's very important. It's very important to know how to brief a senior. But now, when it comes to briefing a senior, there are two aspects. One is briefing in a conference. Conference means when you're sitting with a client or the lawyer who has come, who has drafted the matter, and
Mm-hmm.
you yourself who has actually contributed either in the drafting or preparing notes for your senior. So that internal conference which happens in which a client is sitting, a couple of more lawyers, and you as a junior or a senior, you're sitting together. There, the first briefing is done there in that
Mm-hmm.
office, and the second briefing is done when the senior is arguing the matter in the court. So
Right.
there you have to make sure that whatever your senior is presenting before the court, you're ready with those relevant judgments, you're ready with those relevant averments which he's making with the before the court. So there are two aspects. When it comes to briefing a senior in the office, you have to make things as convenient from him as possible, or him or her. So it's like, when you're briefing a senior, you should prepare a list of dates. We call it LOD. So
Mm-hmm.
this is a very important document. The reason is that the facts which are provided there in the brief, that should be jotted down in a chronological order,
Right.
right? When you have a grip over the facts, then it's easy to apply law on those facts, because that you have been reading every day, but every case has a different set of facts. So that's something which is difficult part, at least in criminal side of practice. It's a
Mm-hmm.
very difficult part to have grip over the facts. So,
Right.
when a matter is it comes to you, the first thing which you should do is you should prepare a list of dates in which all the facts are important and relevant facts are provided in the chronological order. Then after preparing those list of dates which includes all the facts in the chronological order, I think that the second thing which one should prepare, I mean, I've seen very good briefing lawyers of their own time,
Mm-hmm.
and when I used to work with Mr. Praveen Parekh, I realized, because earlier he was an advocate on record, and
Mm-hmm.
his firm P.S. Parekh and Company was one of the best litigating law firms of the country in his
Mm-hmm.
time. So there I've seen his approach. His approach was to prepare proper list of dates. His approach was to then prepare the written submissions. After preparing written submissions, the grounds which are to be taken there in the court, relevant page numbers, and then there is marking of the judgment. When you file 136, take for example, this is one
Mm-hmm.
set of litigation which I'm trying to
Right.
explain, because briefing in every matter is a different thing. So
Mm-hmm.
the most of the matters which are conducted in Supreme Court are under 136 of the Constitution.
Right.
Okay. So it's a special leave petition. So a
Mm-hmm.
special leave petition is majorly made into 8 paragraphs. There can be multiple sub paragraphs, but the major paragraphs are 8. So it's like first preliminary paragraph, then the questions of law, then the third paragraph will be the ground. See the common paragraph, that these are the annexures, these are all those copies, and then fourth will also be an undertaking. Then fifth will be the grounds. Then sixth will be grounds for interim relief. Then the seventh paragraph will be prayer, and then the eighth paragraph will be prayer for interim relief. That's how a
Right.
special leave petition under 136 is made. but the special petition starts with page 1, which contains impugned judgment.
Right.
Okay. So then there is marking of that impugned judgment. Whenever the High Court or the court below, they've relied on certain relevant document, and if that relevant document is the part of the annexure of the special petition, that marking is done there. That okay, this document on which the court has relied upon, that is available on that and that so and so particular page number. That also
Right.
makes things convenient for your lawyer. So before the brief or that case file which goes to the senior, if it has a proper marking in the impugned judgment, because that's the most important document, that's the
Mm.
document which you're questioning before the court. So then when you get to know, okay, these are the documents which are being relied upon by the court below, and these documents are available on so and so page number of the paper book or the case brief. So that makes things convenient for the senior whom you're briefing. List
Mm-hmm.
of dates, marking of the judgment, relevant page number should be flagged, and all those things are which are very important. And then you should be aware of each and every aspect of that case, because you don't know what is going on in your senior's head and what questions he can ask you. And
Right.
then when a
What?
senior like a senior like Ram sir, when he asks a questions, you have to make sure that you're able to reply to that question,
Right.
because you yourself feel so guilty about it. The way that this is one question which he has asked and I was not able to answer, and you feel like, okay, I'm not ready with the brief, and that is another guilt which you have as a lawyer on
Right.
yourself. So that's how it is. I feel like that you just have to be prepared with the matters, and you whatever way, maybe there might be people who might be more creative and more productive, and they make things more convenient for their senior in their own way. But
Mm-hmm.
what you have, the object while preparing a brief or briefing a senior should be to make things as convenient as possible for your senior who is going
Right.
to argue the matter before the court.
As simple, as convenient, and anything that if they ask, you should be ready with an
You
answer.
should be ready with an answer. I mean, when you're ready
Right.
with the brief, most probably at times when briefing Ram sir, otherwise he himself prepares everything. He used to prepare everything by himself. But then if he used to ask question, that question was so deep somewhere, maybe is there anywhere written somewhere in the 161 statement of so and so witness that this has been stated, and then you have to recall that one line on so and so page number, and then you have to answer it to him, or you have to search before him, and if it takes more than 5 minutes or 2 minutes for you, he'll be able to find it himself.
Huh.
So that's a very embarrassing situation for yourself when you're not able to answer something and he's able to find it on his own. That too when he's first time reading that brief. So that's
Okay.
how that's how it happens.
Right. So it was a great discussion on, the myths, the first time litigation lawyers, then how initial years you enter litigation and how your life is, and how can you establish yourself as a good litigation lawyer. Now, one thing that is there before we end in my mind is your 2 cents in how to become a litigating lawyer and a good one, and working in that area, working in that zone, uh, be it you're practicing it independently or with a law firm, doesn't really matter, but you are having good clients, you're having good work.
Mhm. So I think that when you're working as a lawyer, wherever you are, maybe you are working in a corporate firm, or you're working in a litigation firm, or you're working in a chamber, or you're working anywhere else, the first thing which is most important is to have a good communication skill. Because
Right.
until and unless you are able to communicate properly, or formulate what you have to present, then it will be a difficult thing to survive in this profession. Because even as an academician, you should have a good oratory skill, so that your
Right.
students can learn from whatever you know in the best
Right.
possible way. Like I've heard the lectures of Professor Faizan Mustafa, the present Vice Chancellor of NALSA. He used to teach us constitutional law in our college. So, you know, everyone used to attend his lecture because of his oratory skills and the content, the simple way in which he used to present those content. Those complex issues were explained to us in such a, precise manner, as if everything we don't even had to refer to some textbook after hearing his lecture. So I think communication skill is something which is important in this profession, and communication skills means that you should have writing and speaking skills both. It's like
Right.
when you're
And it
drafting something.
includes, I think,
Mm.
researching, writing, speaking,
Yes, 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 yes,
oration.
yes, yes,
Yeah.
yes, yes. Research is another important aspect, because every day nowadays Supreme Court at times they are being very pro active approach towards interpreting laws and providing new dimensions to the law. So then you have to be updated. You should know what the present law on that particular aspect of proposition is, or
Right.
whatever on some set of facts. What how 304, like recent judgment which has been passed by Justice Bose and Ramna, in which the provisions as provided in section 304 IPC, 304 B IPC has been dealt with. So,
Mm.
you have to be updated. You should have good research skills. You should know how to find out relevant case law. You should know how to find out relevant provision in a law or a statute. And then only you'll be able to, apply those principles while you're presenting your case before the court or drafting any petition. So
Right.
that's how it is. So you should have good communication skill. You should have good research skills. Then you should have good, understanding of how to deal with clients. Then these are all important skills which one should take care of. Then after, apart from dealing with clients, it's also important to deal with, it's important that, you should how to control your temper. That's very
Mm.
important. You should not have those, ego issues when you're presenting a case, because at times the judge, they don't have merit. They feel like that the case might not be having merit, and then they ask you some questions when you might at times, becomes little aggressive, and that's maybe you don't portray yourself as an aggressive individual, but then the judges, they sense that okay, this person is someone who is bringing his ego when we are asking some kind of questions to him.
Mm-hmm.
Then they realize it, because they are hearing whole lot of lawyers in a day while sitting there in the before in the on the bench.
Right.
So then you should not have those temperamental issues, and it should be like that. You should not be aggressive. You should be as polite as possible to the bench, and as in a very honorable manner, you should present your case before the court. So all these things one should take care of while you're dealing with basic nitty gritties and nuances of a case or a matter or day-to-day life as a lawyer.
Right. So that was an eye-opening thing, and I'm sure many are now benefited because of knowing a little bit about litigation, getting a clarity as to what it really is. And my only last thing is that unless you do it, you will not understand it. So better give it a try before you cancel that option, or you just get into that option. Give
That's
all
that's the
possible try.
most that's the most important thing. I mean, I'm not saying that litigation is the only good option available to you. It's one of the good options. So it's like, in case if you want to go into litigation, first have exposure of litigation. If you want to become a corporate lawyer, you should first work under in a corporate firm, and you should know you should put all your efforts as a law student. You should participate in moot court competitions. You should participate in debate competitions and various other, research paper constitution, essay writing competitions, which are always there, apart from your basic syllabus and curriculum, which you have to finish and score good grades. So I think that before leaving out, this is one thing which every law student should know and should understand, that before leaving or just ruling out any option, you should first have an exposure to that particular option and then rule it out.
Right. That is very important, I believe, and that's how you should plan your career also, because it should
Plan your
not be
career.
a
That's
certain whim or fancy. Okay, I want to do this because I've seen a series regarding it and it was
that
very
should not be there,
interesting.
because because what you see there in web series is altogether different from what you actually do there in court or in a firm. No
Right,
one is Harvey Specter of suits, or the lawyer who is there in Boston Legal.
right.
That's how it is. Not like that.
Thank you so much for your, telling us the nitty-gritties, clearing those myths. It was lovely having you here and, discussing those things with you. And I'm sure many have benefited out of it. And with this, I'd like to give a big thank you to you.
My pleasure, Kriti. It was really, a very good interactive session with you, and I've also learned a lot in terms of how to conduct a session in case if one has to conduct. Okay,
Right, I know. So thank you so much. And with this, I end the session. Take care.